Here in Portsmouth Courts of Justice this afternoon on the 13th of March 2024 in Court 9, a further injustice was carried out against a 22-month-old child who we have been raising serious concerns of child protection issues and alleging sexual abuse. The child is currently in the care of Isle of Wight Social Services in a foster care placement. We are putting on notice Judge J.P. Miles, Tracy Hennessy, number 18, Chambers, Southampton, Gemma Bauer, College Chambers, Southampton, and we are demanding immediate, urgent attention to this case. All persons complicit in this case are on notice to be held liable in their personal capacity. All plausible deniability has been removed. To protect this child, in light of the reports made and the inadequacies of authorities to act, evidenced facts of harms by photographic medium, we find it untenable for this court to adjourn without providing further safeguarding measures. The numerous incidents have been catalogued and reported to Social Services, Hampshire and Isle of Wight Police Constabulary, and now brought before this court in Portsmouth City on the 13th of March 2024 for an emergency hearing. An emergency hearing that wasn't listed on the court list. To adjourn without taking emergency measures would be an error in law and make the presiding judge complicit and thus liable for any harms hereafter. We request immediate intervention by way of an emergency court order to extract Evea from the current temporary care accommodation into the place of safety with immediate effect. Subject to safe provisions, however, to include hereafter immediate medical and welfare checks and visitation by family members to continue the family bonding and oversight by the concerned nearest family. We have no objection to adjournment after such order is issued today, 13th of March 2024, before Her Honour Judge J.P. Miles, making the immediate extraction to a safe place in local vicinity of the nearest family member or members. We welcome an adjournment for the hearing to take place in a higher court as soon as practically possible. The current position of safety for Evea cannot be accepted as honest belief from the word of social services or the police, who have failed to act on photographic evidence of harms witnessed at regular family visits. Derry versus Peake, 1889, deceit amounts to fraud with no honest belief, and fraud is time immemorial. Should the judge and the court not grant an emergency order for safe extraction, then it may be necessary to make the position of the judiciary and individuals responsible public to halt further ignorance of the law and permit harms.